So welcome to an oral argument session for the 5th District Court of Appeal. As indicated, we are streaming this live on YouTube and recording it as well. So just be aware of that. My name is Jay Cohen, and I am honored and really privileged to be on a panel today with Judge Dan Traver and Judge Meredith Sasso. It's just a privilege to serve with both of them on this panel today. We've got the case of Armstrong versus Jasper Contractors, Inc. Set for this morning. Both sides will be entitled up to 20 minutes each for their arguments. I have a default typically at 5 minutes for rebuttal, but if the appellant would like something other than that, then that's fine. I'll be glad to accommodate whatever you'd like. That's case number 20-178. I'm going to take a shot at this. Is it Laylu Amini? Do I have that? Am I even close?
Sarah Lalu Amin.
Amin. Okay. All right. Too many vowels at the end of it then. All right. Well, we are ready to proceed. At your convenience, you may begin.
Thank you, Your Honor. Good morning, and may it please the court. Sarah Lalu Amin on behalf of the appellants, Deanna and Stephen Armstrong. And I'd like to go ahead and reserve the default 5 minutes for rebuttal, please.
You got it.
We're here, thank you, Your Honor. We're here because my clients have had their counterclaims compelled to arbitration, where the plaintiff's claim that pertains to the exact same facts remains in the trial court to be litigated there. The result of this incongruous ruling, as the Shaken Court called it, is an utter waste of judicial efficiency and litigation costs that run the very real risk of conflicting results and prejudices my clients. And if it weren't for the obvious—
Can you address, just as an initial matter, the order granting rehearing in this case was entered after the notice of appeal was filed. Is that correct?
That's correct,
So,
Your Honor.
General rule that, if the matter being considered by the appellate court is the same, which the trial court rules on, the trial court is without jurisdiction to rule on that which the appellate court is considering. So I'm struggling to see how that order would not be a nullity. Can you address that matter?
Your Honor, yeah, absolutely. That order is very limited, first of all. So the court, we again raised the evidentiary hearing, the lack of an evidentiary hearing issue among the other issues, and the court agreed to hold an evidentiary hearing. So there hasn't been an order giving any relief yet, but the nature of the order is simply allowing an evidentiary hearing solely on the issue of agency, denying it as to everything else in terms of an evidentiary hearing and in terms of, rejecting our position. So
So is it your position that the trial court did have jurisdiction to rule on that limited issue, even though the issue of arbitrability is on appeal?
Your Honor, I think that the court had ongoing jurisdiction, although that pertains to the same issue that's now on appeal. The result is effectively moot because it hasn't moved forward. And we did seek a stay to allow the trial court to decide it, and this court denied that. And so things are kind of at a standstill in terms of the trial court proceedings. And so that, the status quo remains in terms of the order that's appealed.
Ultimately, why wouldn't remand for an evidentiary hearing on the agency issue be appropriate?
So remand for an evidentiary hearing on all issues might be appropriate, but on solely the issue of agency, the real threshold issue is the existence of a valid agreement to arbitrate. And there was no evidence presented whatsoever, just simply the copy of a purported contract, a purported 2-page contract, the first of which has a signature of Mr. Armstrong, and the second of which doesn't have any signatures, any initials, or anything. And it wasn't even supported by, the bare minimum of a business records type affidavit. There's just nothing to support the court's order compelling arbitration on the basis that a valid agreement to arbitrate exists. And so that is the threshold issue. And so, if waiver is kind of an issue that takes care of everything, because if they waived it, then none of this matters and the case just proceeds in the trial court as it should. But if there is still an open question as to that threshold issue of the agreement to arbitrate, the existence of an agreement to arbitrate, then an evidentiary hearing absolutely must be had on that issue in addition to the agency issue. So certainly one of the remedies available is to remand for those purposes. But we would further argue that as a legal matter, the waiver issue precludes relief in the form of arbitration in this case. So
it seems to me, and if you disagree, please say so, but it seems to me that the law as it relates to motions for rehearing in the context of a non-final order, it seems from my review at least that once that final notice of appeal is lodged, you abandon your motion for rehearing. And again, if you think differently, please let me know. But the effect of abandoning your motion for rehearing would be that you need to argue the agency issue on appeal. Assume for me that I think that that might be a winning proposition for you. Have you successfully preserved that agency argument on appeal? And if so, where in your initial brief did you do that?
Yes, Your Honor, absolutely. So we preserved the request for an evidentiary hearing on the issue of agency and throughout the briefing, and I'll find the precise site for Your Honor as to that. But we certainly did request an evidentiary hearing below and in the briefing. That is one of the issues on appeal is the existence of a valid contract. And part of that issue is whether there is a valid contract as to Mrs. Armstrong, and that implicates the agency issue. And so we did also seek a stay, but again, the status quo remains the same because we were forced to proceed with the appeal because certainly the law is also clear that an order on rehearing is not appealable. And so we could not wait that process out absent authority from this court. So we're here to cover all the bases and ensure that my clients get review of these issues and that my clients are permitted to hold Jasper to its evidentiary burden that it was required to satisfy. And so that is a potential outcome of these proceedings. But as a matter of law, there is no basis to move forward with arbitration in this case because the waiver issue legally precludes them from doing that. And so
I know you want to move on to that, but as it relates to where in your brief specifically you preserved it, it looks like our decision is going to be based on section C, which is 4 paragraphs at the end of your initial brief. It looks like in that first couple of paragraphs, you make what could be characterized probably as a general argument that evidence should have been taken. But then in your last 2 paragraphs, you talk exclusively about effectively whether or not that second page was combined into the first. I don't necessarily see where in section C you specifically argue the agency theory, but persuade me otherwise, please.
And Your Honor, I'll take a moment as I'm awaiting my rebuttal to review in full. But we also did elaborate further in response to Jasper's arguments in our reply brief, and that's in pages 9 through 11 of the reply brief as well. But certainly,
well, but you can't raise an issue for the first time in your reply brief.
Of course, Your Honor.
Problematical for you.
Of course. No, I'm just pointing to the areas where it's elaborated upon further, but there is certainly a general argument on this evidentiary issue. The evidentiary hearing was granted for purposes of the agency issue, and so the court has agreed to hear that. Because of complications with COVID-19, that evidentiary hearing didn't move forward in this process, and we did request a stay to allow that to happen. So as it stands now, we haven't been in a position to be able to appeal the resolution of that issue. And in terms of the evidence to support the existence of a valid agreement to arbitrate, the threshold question of the existence of the contract, and further, any evidence that Mrs. Armstrong could be bound by that contract is not present in the record, and that was Jasper's burden. And I will take a look at that more closely, for Your Honor, in the period in between. But certainly we raised that issue, and through our motion for stay have raised the issue of needing to ensure that we are able to preserve review on all of these issues and not be harmed by kind of the procedural happenstances of this case. So I would like to, refer Your Honors to the motion for stay as well, and the attempts that the appellants have made to ensure that all the matters remain before the court so that they can obtain review on those issues.
Well, but the procedural aspects are critical to preservation of error. That's the difficulty from, looking at it from an appellate court perspective.
Absolutely, Your Honor. And for those reasons, we did, attempt to kind of keep the appeal in abeyance and cover all our bases that way, while this issue is pending in the trial court. It hasn't been resolved. The court, has agreed to take evidence on that point. It hasn't been resolved at this time. But in the meantime, there is no evidence. And so the issue, generally speaking, is that there is no evidence of a valid contract, and that evidence is required. That evidence is Jasper's burden. And we've cited the Palm Garden v. Haydu case, the Davis v. Hearthstone case, Basalto v. Hialeah Automotive. All of these cases involve evidence. And so when we're looking at evidence of the existence of a contract, that's with respect to Mr. Armstrong and Mrs. Armstrong. Now, Mrs. Armstrong has this additional issue of agency as to her. And certainly Jasper is arguing that there is agency as to her, and she is bound by this contract. And therefore, that kind of jives with its waiver argument. So it has to take that position. It takes the position that she is bound by this contract. And so the way that ties into waiver, I would like to address, because if Jasper is taking the position that Mrs. Armstrong is bound, then most certainly there was a waiver, because it sued Mrs. Armstrong for defamation. And so I do think it's important to reach that threshold legal issue, because it kind of nips everything else in the bud. And it really addresses everything without the need for further evidence. But certainly if the question is still open, then that evidence needs to be taken on all issues. So certainly we've preserved the right to prove up this contract, which Jasper simply attached to its motion, and the court simply accepted over our objections with the request for an evidentiary hearing in place and denied that relief.
Is it your position that an evidentiary hearing is always required for a court to determine the threshold issue of the existence of a contract, or was there something about this case that required the evidentiary hearing?
So this case required an evidentiary hearing, Your Honor, because in this case, the existence of a valid agreement to arbitrate was disputed. And that's not always the case. Often the existence of the contract, may very well be stapled.
Wasn't it just disputed, though, at the hearing by arguing over the effect of that separate terms and conditions page and whether or not that was actually signed by Jasper? That it was essentially you're arguing over the construction of a document, rather than presenting any evidence at that initial hearing of a dispute.
So a dispute was in place. There was a dispute by my clients as to the existence of a valid contract, and that dispute was raised. It was raised kind of more generally in the response in opposition, and most certainly at the hearing, throughout the hearing, pages.
But just the existence of a dispute, right? Anytime there's two parties on a case, there's going to be a dispute. And the statute allows a court to summarily determine the existence of a contract. So what about this case required an evidentiary hearing on that limited threshold issue of the existence of contract?
So this case involved a dispute as to the existence of the contract. So yes, there's always a dispute, but as to the existence of a contract, did I sign that contract? Did I sign both pages of that contract? That is not always in dispute. And rarely is it, perhaps. You know, parties often agree as to what the contract they signed was. And here they don't. And here that's clear at the hearing, and my clients have preserved their right to an evidentiary hearing to determine what that contract actually was, in addition to—
Is a fair reading of that contract, though, and I think the trial judge pointed this out, I mean, is a fair reading of that contract on its face that it incorporates terms and conditions?
Your Honor, I'm glad to speak to that point, and I would like to refer to some of the language in the contract there. So if we look at the contract, it does reference, I believe the portion Your Honor is referencing is at the end. It talks about terms. I, owner, have read and understand all statements, terms, and conditions of the roof replacement contract. So roof replacement contract is in quotes, and that's the label for this contract. That's what it says right up there at the top. Terms and conditions are not in quotes. Jasper knows how to refer to something outside the contract when it wants to. If we look at that alleged second page, we can see that there are things that are referenced that are outside of it that are, again, put in quotes. For example, the 2-year labor warranty, about a third of the way down, there's a definition there, and it says that it's incorporated by reference. And that is not the case with respect to terms and conditions. And so if we go on the premise, which again, there's been no evidence to this effect, but if we go on the premise that someone's presented with this first page only, and this second page isn't even shown to them, which is something that was addressed at the hearing, if we go on that premise, there's no reason from reading this contract to think I now have to go outside of this contract and find a separate document entitled terms and conditions, because it doesn't say that. When we look at these two things together, Jasper can certainly make that argument, and it can most certainly provide evidence to that effect, but it hasn't done that as of yet, and that was its burden.
Right, you got a little bit over 5 minutes left.
Thank you, Your Honor. 5 minutes plus my rebuttal, or I'm
No,
into
5 minutes is your rebuttal. Time flies when you're having fun.
I'm having so much fun, Your Honor.
I know.
So I do want to address briefly this issue of waiver, because Jasper's position relies on this notion that Ms. Armstrong is bound by this arbitration provision. And if that's the case, Jasper most certainly waived arbitration here by initiating this lawsuit. It initiated the lawsuit, and under this court's ruling in Beverly Hills v. George Wimpy, as cited in the Pearson case that we cited in our brief, initiating is waiver. It's participation at the highest level, in fact. And so Jasper absolutely waived arbitration here by initiating the lawsuit. And we've cited many, many cases that address the issue of defamation, address the issue of counterclaims. This position we have here, where there's a claim that implicates underlying facts, a counterclaim that implicates those same underlying facts, and arbitration cannot go forward at the urging of the plaintiff in that instance because the plaintiff waived. And the Roth case combines both concepts, where we again have this anticipatory kind of aggressive defamation claim that is essentially the defense of my client's counterclaims. That's what we have here. So Jasper won the race to the courthouse, and as a matter of public policy, to reward that by allowing them to split their case and essentially litigate our claims in arbitration and their defense in the trial court would be improper under Florida law and bad public policy for consumers. And so we'd respectfully request that the court reverse. Thank you.
Thank you. All right, Mr. Paul.
Thank you, Your Honor. May it please the court. My name is Jeremy Paul from Orr Cook, and I represent the appellee Jasper Contractors. This court should affirm the trial court's common sense decision that Jasper did not waive its right to compel arbitration by filing a 1-count defamation complaint against Mrs. Deanna Armstrong. This court should affirm for 2 primary reasons. First, Jasper did not waive its right to compel arbitration because the contract and its claim for defamation do not share a significant relationship And second, because the trial court correctly found that pursuant to the contract, all remaining issues regarding arbitrability and validity should be decided by the American Arbitration Association.
Isn't the performance of the contract the whole crux of the defamation case?
It's not, Your Honor. I do agree that falsity is one element of the defamation case, but this is not simply a dispute, a run-of-the-mill dispute between a homeowner and the contractor. These are commonplace. You've seen these in a lot of the cases that are relied on by both parties. This was something more, and this is something that Jasper takes very seriously in the sense that Mrs. Armstrong didn't just come out and say to the Better Business Bureau, this company did bad work, or this company's work was defective. The key statement that was actionable and that caused Jasper to file this lawsuit was that Jasper exposed her children, her baby, as they say in the counterclaim, to toxic mold. This is something that brings this case much more so under the Seifert umbrella, where you're dealing with.
Listen, we live in Florida, and if a roof is improperly installed and water gets into a home, that's what happens. That's part of living in Florida. So I'm still struggling why this isn't related to the contract, or it's wholly unrelated, as you stated, and I just don't see that.
Wholly unrelated in the sense, Your Honor, that resolution of Jasper's claim will not require reference to or interpretation of the contract. We don't dispute that the only reason my client was out at this property was because of this contract. But to state the obvious, there's nothing in this contract that talks about mold. There's nothing in this contract that talks about defamation. There's nothing in this contract that talks much about the progress of the work, which was the exact case in Seifert. This was a standard contract that the developer in Seifert used for, it was a design build or a cell build rather contract. So it did not lay out all of the requirements for the work. And most notably, it didn't mention anything about tort claims, which was a key distinction that the Seifert court picked up on. So yes, we are in Florida. Yes, mold may be more common for us than someone in Michigan. But this statement, again, goes far beyond this contractor did bad work and that resulted in mold. The implication here is that Jasper, when you read it, it's almost, at least the allegation is that they're implying that this is something Jasper did deliberately, and coupled with the fact that Jasper had already been out to this property and heard statements from the homeowner that after the water testing, I don't think it was you guys. I think it was something that my HVAC contractor did. So from Jasper's perspective, 6 months after it completed its work at this project, to see these statements, particularly the mold statement, and that they're a disreputable company, which of course has nothing to do with the contract. So again, I don't think resolution of this complaint, while it may address some aspects of Jasper's work at the property, the test which this claim and complaint and contract don't meet is whether there is that significant relationship.
Do you think that you raised the preservation of error issue
with respect to the agency issue?
Well, with respect to whether they could go forward based upon the procedural nature of the case, whether for appellate purposes that they preserved it.
Well, we did not address that in our answer brief. The answer to that is no. We didn't address in our answer brief, though, to answer Judge Traver's question, because it wasn't raised in the initial brief. So we're not obligated to respond to arguments that essentially aren't made in the initial brief. I don't.
Well, if you thought there was that the error wasn't preserved, you don't think you have any obligation to make that argument?
Well, I don't know that we do have an obligation to make an argument in response to an argument that's not made in the initial brief. I think the expectation of both sides was that that issue was going to be heard and ruled on within months. I don't think COVID.
I'd like to ask you about that though, because it seems like a fair reading of your answer brief is that you think that this appeal only relates to Stephen or Mr. Armstrong, I should be more formal, and not Mrs. Armstrong. Is that a correct statement?
Based on our answer brief, yes, Your Honor. And again, it's because there's nothing in the initial brief that addresses the agency issue or that discusses Ms. Deanna Armstrong and whether or not this contract should apply to her. Prior to the briefing in this case, the order granting reconsideration was filed. And candidly, Your Honor, I have not looked at the issue of whether by appellant moving forward in light of that order granting partial reconsideration, them going forward with this appeal, whether or not they've waived their ability to go forward with the trial court and that their only recourse would be to this court. I candidly have not looked at that issue.
Let me ask it a different way. And I think that makes sense what you're saying, but let me confirm. If we affirm the trial court's decision, is it your thought that arbitration is only going to be ongoing with Mr. Armstrong or with both Armstrongs as it relates to the counterclaim?
Well, my thinking as it stands right now, aside from any ruling by this court that by not raising it in the initial brief, the appellant has waived it, is that the arbitration would only go forward as to Mr. Armstrong unless the court denies reconsideration as to the agency issue and upholds the original ruling that the counterclaims of Ms. Deanna Armstrong and Mr. Armstrong, which are identical, both go to arbitration. I think practically speaking, if only Mr. Armstrong's claims go to arbitration, we're going to request a stay of Mrs. Armstrong's claims in circuit court because they're the identical claims. But as we pointed out to the trial court.
Well, let me ask, would that be appealable? I mean, let's say it goes back and the trial court makes whatever ruling that they're going to make as to Mrs. Armstrong. Why wouldn't then, since this appeal only dealt with Mr. Armstrong, why wouldn't that be appealable?
Well, I think if the trial court granted or denied the motion for reconsideration, rather, or ultimately ruled on that agency issue that the contract did apply to Mrs. Armstrong, my initial reaction to that is, yes, I do think that would be an appealable order. Again, not precluding this court in this appeal to say because that issue wasn't raised in the initial brief that the appellant has waived it and waived their ability to move forward in front of the trial court. So just practically.
An argument that you've never made.
We did not make that argument in the answer brief, Your Honor.
Do you agree that the notion that there should have been evidence taken as it related to Mrs. Armstrong is a valid one?
Yes, it's a valid one. I think the question is taken by whom. I think in the hearing before the trial court, we advised the court that if there was evidence that was needed about any issue based on the case law, that in all candor, it likely needed to be taken on the agency issue, which is very likely why the trial court, in looking at the transcript and going back over the briefing submitted by the parties, granted reconsideration as to that issue. But I think that issue, like the validity issue and the enforceability issues that were raised, are issues that, pursuant to this contract and pursuant to this court's opinion in the Reunion West development case, need to be decided by the arbitrator. And that's pursuant to Rule R9 of the construction arbitration rules, which states that the arbitrator shall have jurisdiction to, or shall have the power or the authority to decide its own jurisdiction, including any objections to the validity of the arbitration agreement or arbitrability. So we've never disputed.
Those are two really different things. So validity and arbitrability, correct?
Correct.
So, yeah. So if the underlying argument from the perspective of Mrs. Armstrong is, hey, I never signed that, isn't that different than arbitrability? Or are you reading them as one and the same? It's just threshold validity, right? I signed or I didn't sign that. It's valid to me or it's not. That seems like a trial court decision.
I think, and that's candidly, Your Honor, that's why we advised the trial court that if there were factual issues needed. And the reason we disputed that was because the face of the counterclaim, in the counterclaim, the Armstrongs alleged that they hired Jasper. They didn't allege that Stephen Armstrong hired Jasper. They didn't allege that.
Yeah, that's generic. We don't know what that means. I mean, you're trying to read that broadly, but that's a pleading. It's generic. I don't know that it means much of anything.
Well, Your Honor, it's an allegation. I will grant that, but it's an allegation that if we stipulated to, if we admitted, that would be a fact that existed as a fact for the remainder of the case. So I think you have to look at that allegation and assume they mean what they say. And that way, it wasn't just the allegation. That was coupled with, again, the face of the contract, wherein Mr. Armstrong represented in that same terms and condition paragraph that by signing, he was representing to my client that he had the full authority and power to bind himself and all those he's representing to this agreement. And I also think you have the common sense fact that Mr. and Mrs. Armstrong are husband and wife. They jointly own this property. But again, there was no additional evidence that we felt like the court needed to take at the time. But we advised the court candidly, if the court was on the fence about the agency issue, about whether or not there was a sufficient agency issue, we said we'd be happy to come back and put on evidence of that. And Judge Traber, to your point, I think there is a difference between contract formation. In other words, was there ever a contract, and enforceability or validity of a specific arbitration agreement? So again, that ties into why, at the end of the day, we were more comfortable advising the trial court that if you have a doubt about contract formation as it relates to Mrs. Armstrong, then maybe that is something that we need to put evidence on. Although reading Rule R9 and reading this court's opinion in Reunion West Development, I do think R9 is broad enough to encompass that dispute, and that is an issue ultimately for the arbitration panel to decide. And I think that's true for the other validity arguments and the other arguments that I read in the briefs and heard before the trial court. These were arguments that again, these arguments were made in the Reunion West Development case. The original order in that case said that there was no valid agreement because there was no meeting of the minds. And there was also a finding in that case that there was no arbitration agreement because the agreement was unconscionable. And this court in Reunion West said, no, pursuant to this incorporation clause, that is clear and unmistakable evidence of the party's intent to defer that issue to the arbitration panel. We have identical language in this case. The contract in Seifert actually had that same language as well, but that did not appear to be an issue that was taken up. So we believe that the validity issue and the other issues that were raised, the trial court was correct in finding that those issues pursuant to this court's opinion in Reunion West need to go to the arbitrator. As to the waiver issue, Judge Cohen, I agree. It's not always an easy call with the significant relationship test. I think even the Seifert court admitted this is a test that's been applied, or an analysis that's been applied with some difficulty. But the case that I think the appellant is relying most heavily on is the Roth case. This case is not as similar to the Roth case as it is the Seifert case. And the key distinctions with the Roth case, the statements in that case, and this was true in the Caribbean case that appellants are relying on too, the statements that were made were statements about specific, unique duties that arose from the contract. And the statements in Roth in particular were about invoices that were only generated pursuant to the contract. They were invoices described in the contract, and it was about
specifically, Jasper's complaint mentions the allegation, without quoting specifically the statement, that Jasper performed defective work. So wouldn't performing defective work, determining the truth or falsity of that statement, require reference to the contract?
I don't believe it would require reference to the contract any more than the complaint and the wrongful death claim in Seifert would require reference to that contract. Because again, this is not just a simple dispute between a homeowner and contractor. Judge Sasso, if that was the only statement that Mrs. Armstrong made, that Jasper performed defective work at my house, I don't think we'd be here. But it's that statement coupled with, and by the way, Jasper exposed my baby to toxic mold and they're a disreputable company. I think looking at those statements combined, that takes it far beyond the contract. And if you look at Seifert, yes, the claim did share some relationship to the contract because the allegation was my husband died because of work that the contractor performed. So I don't think the Florida Supreme Court in Seifert was saying if there was work performed pursuant to a contract, any tort claim or any claim whatsoever after that requires reference to or interpretation of the contract to meet the significant relationship test. So I don't think the connection here is any more or less than it was in Seifert, and for all the same reasons that the Seifert and Jackson courts discussed, the reference to the contract in this case is not enough to meet that significant relationship test. I also think it's important in Roth, putting the significant relationship test aside, I don't think there's enough conduct in this case by Jasper just in simply filing their complaint to amount to a waiver, to amount to a knowing relinquishment of that contractual right. And I think one of the key aspects of Roth was that there was merits discovery. And this court held, I believe it was in Saunders or Boylan, that even asking a few merits questions at a deposition, even if there's a motion to compel arbitration pending, that in and of itself expresses that desire to waive a known right and would amount to waiver. So you don't have merits discovery in this case. You don't have defamatory statements that relate to specific provisions or specific duties in the contract. I mentioned the Caribbean case earlier. In that case, the contract required letters of employment, and the fraud and defamation complaints claims in that case specifically referenced those letters of employment. So again, you have that connection that the Seifert court was describing, and that was explained more so in Jackson. So in this case, yes, there was a contract. No, it does not meet the significant relationship test, and the trial court was correct in finding that there was no waiver and that all remaining issues regarding validity and arbitrability should be decided by the arbitration panel pursuant to the contract, and we would ask this court to affirm.
Thank you, sir. All right, Ms. Lalo Amin.
Thank you, Your Honor. So I first want to address this existence of a valid agreement to arbitrate issue and confirm and clarify that it is as to both Mr. and Mrs. Armstrong. This order was entered as to both, and it's appealed as to both. And the existence of a valid agreement to arbitrate is the first of the three issues that a trial court is to consider. And it is Jasper's burden to establish this on an evidentiary basis where that's challenged. And so the existence of a valid agreement to arbitrate is the umbrella. And underneath that is evidence as to, Mrs. Armstrong's signing on by agency and so forth. And so generally speaking, it applies to both. And generally speaking,
it seems to me, and I don't think I'm misstating Mr. Paul's position on this. It seems to me like Jasper is acknowledging that there's an evidentiary issue as it relates to agency. So that could theoretically be a winning position on your part if you preserved it. Could you address how you preserved it in your initial brief?
Yes, Your Honor. And so the argument is general in nature in that it's under the scope of the existence of a valid agreement to arbitrate as to Mr. Armstrong and Mrs. Armstrong. The argument in the initial brief doesn't address the agency issue in detail because there's no evidence yet. And so that evidence has to be had And the court has agreed to do that on that limited basis, but the evidence has to be had as to the validity of the existence of an agreement to arbitrate, period. And that is what we've preserved. And all of the issues come under that umbrella because we don't know what the evidence will show. And once we determine what the evidence will show, we'll know what the positions are. But as of yet, there's been no evidence in support. So this order fails because there's no evidence supporting it across the board. And so
this almost has the feel of dominoes, where because if you've abandoned, if that order that grants the evidentiary hearing is a nullity, and then you've abandoned the issue on because you filed a notice of appeal, don't you have a house of cards that's fallen?
Your Honor, so that's just as to the issue as to Mrs. Armstrong on that one component of the validity of the existence of agreement to arbitrate. And so there's no evidence of this contract, period. And so there's nothing to raise specifically in terms of a challenge as to the evidence because we don't even know what that would be yet. So the evidentiary hearing has to be as to the existence of a valid agreement to arbitrate. And that would certainly include Mrs. Armstrong's claims that the court has already agreed to have an evidentiary hearing on. And the abandonment of the argument that, there is no evidence, the argument's preserved and the evidence is not there in the record. And that was Jasper's burden. So looking at the record alone and looking at that order can't stand because there's no evidence supporting it. And whether there may be a further appeal, depending on a court's rulings based on evidence on a different day, that's a different question. But as the order exists now, it can't stand because there's no evidence supporting it. And further, there's no basis, I'll briefly conclude, there's no basis for compelling arbitration as a matter of law because this court can find on this record, and Jasper agrees that it's appropriate for this court and for the trial court to consider the issue of waiver. And based on the case law that's very clear on the issue of defamation where it relates to a contract, and this most certainly does. This is a roofing contract. So the idea that this Royal Caribbean, the contracts for letters of employment and the defamatory statements were about letters of employment, these alleged defamatory statements were about roofing. And that's what the contract is about. Thank you so
All right,
much.
thank you, counsel. Thank you both. Well-argued case, and we will be in recess.
Thank you.
Thank you.